Now, what is the role of licensing in business and economy? The first question is intellectual property wealth in itself? Well, we say that in the knowledge economy, intellectual property is wealth, but intellectual property is not wealth in itself. It can be converted into wealth by its exploitation, and licensing is the major way in which intellectual property is exploited. Is it really, the second question is it really possible for the creator to utilize his property himself? Well, that may be the case in many cases, but in most of the situations, the intellectual property is utilized by somebody who is not the owner. That means the owner invites somebody or permits somebody to utilize his intellectual property, and that permission is known as a license. The third question is it possible or feasible for businesses to create everything in-house in the modern economy? Well, no. Mostly businesses depend, business these days is a collaborative venture. So, you cannot create all the intellectual property that you want or that you require for your business. Many times you create some properties, some intellectual properties, and license in the others that you require. We know it as a fact that the greatest economic value of intellectual property in the modern economy comes from licensing. So, licensing is indispensable to the modern economy. That is the role licensing plays in the modern business and economy. Licensing is also a strategic tool for innovation in various ways. First, licensing allows the owner of intellectual property to concentrate on his core competence. For example, there is a research institution. Now, the core competence of that institution is to do research, is to do fundamental research and make new inventions. That research institution may not be and is not usually competent to take the invention to the industry and thereby thereafter to the market. For that, we have industrial houses and marketers. So, licensing allows this research institution to concentrate on its core competence, that is creativity, that is invention. So, once they invent, they can utilize this instrument of licensing to transfer their invention to the market entities, to the industrial entities, thereby earning through in the form of royalty income. Now, licensing further allows you to access new markets throughout the world. For example, there is a owner of intellectual property, he has his markets in India, but then he wants to expand to Europe. Now, he has no presence in Europe, he has never done business in Europe. It may not be possible for him to directly take his property to Europe for marketing. Thereby, therefore he can use the instrument of licensing and license an entity, a business entity or a marketing entity in Europe to take and sell his property, intellectual property in Europe. Thereby, licensing allows you to grow, allows you to access new markets. Licensing also allows you to test new markets. For example, the same businessman wants to expand in Africa, but he does not know about the business climate, the business environment of Africa. So, before he ventures himself out in Africa, he can test the market through a licensee. He can first license his property to somebody, a business entity in Africa, and if that venture is successful, then he can think of going to Africa himself and doing business himself. Well, licensing is an instrument of turning an infringer into an ally. Normally, infringers are seen as opponents or as seen as enemies of any intellectual property holder, but that is a very impragmatic view and very primitive view. Who is an infringer? Normally, an infringer, if I am the owner of an intellectual property, an infringer is a person who needs my property in the first place, two, who knows how to exploit it. So, if I can shake hand with the infringer or compel him to shake hands with me and try to sell him a license, then he can do whatever he was doing before, he can do it just by paying me my share of his earnings, that is my royalty. Thereby, licensing allows the conversion of an infringer into a friend. Licensing allows the utilization of intellectual property that the owner does not use himself. In the course of its business, a business entity might create a lot of intellectual property, might generate a lot of intellectual property like copyright, like trademarks, like patents, like inventions, etc. So, all those properties are not needed, may not be needed by that business for all the times. So, what to do with the intellectual property that is still current, that is still called an intellectual property, which has not passed in public domain, but it is not utilizable by the owner himself. So, he can invite others and grant them licenses over the redundant intellectual property, which is of no use to him, but which can be of use to many other persons. Then licensing also allows you through spin-offs to take the technology or invention which was made for a particular cause to be utilized for a totally different cause. For example, our past president Dr. APJ Abdul Kalam invented carbon material, which was invented for space vehicle program because they wanted to make the weight of certain components to be very less. So, this carbon material really reduced the weight of the components, space parts or space components significantly. So, the same technology was used for making artificial limbs of persons who had no limbs. For example, a person has no legs. So, we were in search of such a material which was less in weight and at the same time very sturdy. So, this material which was invented for space technology was ultimately utilized also for making artificial limbs. So, all this through the instrument of licensing. Licensing is a strategic business tool, is sort of a partnership, is sort of a joint venture. So, it is a joint venture between the owner of intellectual property and the person who has the ability to exploit it. So, the owner himself may or may not have the ability or willingness to exploit his property. So, he can invite the person who specializes in exploitation of the property and thereby make a joint venture with him. For example, take the case of the author of a book. The author of the book knows how to write the book, but then he does not know how to print and publish the book. He may not have any market presence to market his book, to sell his book, to take the book to the consumer. For that, if he utilizes the instrument of licenses and allows a publisher to take over this aspect of the distribution, publication and distribution of the book, then he can concentrate on his core competence, that is creation of the book, writing of the book. Thereby, there is a division of labor, and through this joint venture, the book is ultimately taken to its audience. Now, what exactly is licensing? Licensing, legally speaking, is convergence of intellectual property and contracts. Primarily, law of contract and IP combine to form the body of law that is known as licensing law. Professor Raymond T. Nimmer, who has authored one of the most important books on licensing of intellectual property, stated, I quote, "Thinking of contract and intellectual property as isolated and discrete boxes of principles is an impoverished idea. Law as a practical discipline relates to human activity which defies being boxed." So, if we dissect licensing law, what do we find? First, it is comprised of law of contract, because every license has to be a contract first. Now, where is this law of contract contained? This law of contract is primarily contained in a statute in India, which is known as the Indian Contract Act of 1872. Further, this law of contract in case of licenses is also contained within intellectual property statutes. Most of the intellectual property statutes like Copyright Act 1957, Patents Act 1970 and Trademarks Act 1999, they contain elaborate provisions as to contracting activity in case of the respective intellectual properties, whether it is copyright, patent or trademark. So, contract law is contained within the Contract Act as well as within the intellectual property statutes. Then licensing law is also comprised of intellectual property law. Further, competition law has a lot of bearing on licensing activity, and most of the competition law issues that arise in case of intellectual property arise in case of its licensing only. Then consumer protection law is also called within licensing law fold, because many times the consumers are licenses. For example, we consume computer software by becoming licensees, and the provider of the computer software is the licensor. So, the provider of computer software, say Microsoft Windows, is not the seller of computer software, he is only a licensor, and when we buy Windows, we become licensees of the Microsoft Corporation. Then taxation law also has a lot of bearing on licensing law. The treatment of royalties, how royalties are to be distributed, what will be the taxation upon those royalty income, etc., they are all governed by taxation law. So, licensing law basically is an amalgam of all these different doctrines of law. Next, we come to the influence of intellectual property law on license contracts. First, intellectual property law defines the scope of the rights, that means the consideration part. When A and B agree, whereby A and B agree to form a contract, whereby A agrees to grant his intellectual property to B and B agrees to pay in return for that grant, what has happened? A transfer of intellectual property. So, the scope of that intellectual property, the scope of that transfer is to be measured in accordance with the law of intellectual property, because it is the law of intellectual property which defines the exact scope of the property and thereby defining the exact scope of law, exact scope of grant. Intellectual property law may provide for requirements over and above the requirements of general contracts. Many times the general contract law may not provide some requirements, for example, writing or signatures, whereas intellectual property law may go above the general law of contracts and provide for such requirements. It delineates the scope of the license by laying down the contours or establishing the contours of the exact rights, the scope of rights that are available. It determines the scope of a license. Intellectual property law many times also provide the default or background rules for a license. The parties to a license may assert certain rights against third parties who are strangers to contract. For example, the law of contract says that only the parties to a contract can sue and be sued upon the contract. But in case of intellectual property law, there are exceptions made to this fundamental rule of contract law, which is also known as the doctrine of privity of contract. Intellectual property law may also provide for compulsory licenses. Normally, contracts are free. We have the theory of freedom of contract. If the party owns something, he is free to contract it out. But in certain cases of regarding intellectual property, the law has provisions for the grant of compulsory license. That means if the person wants a license, he is not required to go to the owner of the intellectual property. Instead, he may go to the state and obtain a license from the state, which is known as the compulsory license. Apart from compulsory license, there is also a provision for statutory licenses in various statutes like Copyright Statute, Copyright Act of India 1957. So, it contains provisions for statutory license. Now, what is a statutory license? Statutory license is a genre of compulsory license where the statute itself has granted a license to everybody, whosoever is willing to comply with the conditions laid down in the statute itself.